Peace, ladies and gentlemen. All right, so today we're going to get into the secure party creditor documents. We're going to get into trust and what documents are necessary in order to claim the estate and claim executorship over the estate. All right. So let me go ahead and pull these up of my drive because I keep everything in my files. All right, as you guys can see. So let's go straight to secure party creditor. All right, so the first thing that we want to get into is a document known as our Declaration of Trust. It's the first thing that we must do. Now, a declaration of trust under U.S. law is a document or oral statement appointing a trustee to oversee assets being held for the benefit of one or more other individuals. These assets are held in trust. The declaration of trust is sometimes referred to as a nominee declaration. All right. So in our case, what we're doing is we're reappointing ourselves as the president over our state. Okie dokie. As the president over the all caps corpus that was created from the time of our birth. Okay. Which is that birth certificate in which they created another copy of. And that's the one that you never actually get. All right. All right. So I already gave you the definition of declaration of trust. Right. So this is the first document you're going to get. And as you see, it says this trust declaration made of between blank, which would be your name in lowercase, and the beneficiary, which would be the capitalist, the all caps. Right. So you're going to put your name in that area. Whereas the trustee is the registered owner of the shares of the corporation, which is, of course, your all caps. Whereas the shares are to be held by the trustees as trustee and nominee for the beneficiary. Now, therefore, this declaration of trust witnesses as follows. And then it goes on to list exactly what our articles are in the declaration. So let's read the first one. The trustee hereby declares that holds the shares in all dividends and interest accrued or to be accrued upon the same upon trust for the beneficiary, and agrees to transfer the shares as directed by the beneficiary or otherwise deal with the shares and the dividends and interest payable in respect of the same in such manner as the beneficiary shall from time to time direct. That's one of the first ones. Now, in the second article, let's read that one. The trustee covenants and agrees that shall at all times exercise all voting rights in connection with the shares and otherwise deal with the shares as nominee for the beneficiary only and in accordance with the instructions of the beneficiary. So who's the beneficiary? You are. You are the lowercase or the first letter capitalized with lowercase afterwards is you, the natural flesh and blood, natural person in full life. You are the beneficiary. Okay, so this is going to be the first form. I'll scroll a little slowly for y'all. Okay, so yes, this is going to be your first sheet. And of course, at the end of this declaration of trust shall be binding upon it and nor to the benefit of the parties hereto and their respective heirs, executors, successors, and assigns. And witness whereof the parties hereto have executed this trust declaration as of the date first written above. And here will be your witness signatures. Okay, it can be you, and then it could be someone else if you so choose to appoint someone else as a trustee. Okay, or it could be you, however. And because you can edit this document when I give it to you, you can add onto it. You can add another line for you to sign your capitalist, your lowercase, etc. with the date. All right, so it's all editable in this degree. So that's the first form. Now we're going to get out of this, and we're going to go now to revoking the trust. All right. So we have secure party revocable trust here. And this is kind of one that I did for someone else, of course. Secured party revocable trust. Now, revocable trust means that you're pretty much revoking the rights of anyone else to be trustee for you and reasserting yours, including the laws that you are now going to be asserting. So let's go into 9-503, Cornell's Law School. Name of debtor and secured party. Sufficiency of debtor's name. A financing statement sufficiently provides the name of the debtor, except as otherwise provided in the paragraph. 3. If the debtor is a registered organization, or the collateral is held in trust, that is a registered organization. Let me read that again for you. If the debtor is a registered organization or the collateral is held in a trust, that is a registered organization. Only if the financial statement provides the name that is stated to be the registered organization's name in the public organic record of most recently filed with or issued or enacted by the registered organization's jurisdiction of organization, which purports to state, amend, or restate the registered organization's name. And that's what we are doing. We're amending when you have your revocation of trust, which is this one here. That's what you're doing. You're reinstating and you're amending anything else in the past from anyone else representing your trust. As we know that the trustees of our birth certificate are your state, is the Secretary of Treasury, is the clerk of vital statistics, XYZ. And the state acts as trustee sometimes. In court, a judge is acting as trustee. You just don't know it. And you can make them trustee for the settlement of any debt with a bond, and we're going to get to that soon. But first, you need to make sure you do this. So your name, last name, uppercase and lowercase, and then first name, uppercase and lowercase. Of course, in parentheses, natural person, trustee under Declaration of Trust, dated 0/15/2021. The Declaration of Trust is made as of the blank day of blank 2021 by and between, which would be your name in all capital letters, like he told you, the corpus, the grantor of that would be your county, and the undersigned trustee, which would be the signator down at the bottom, which would be you in lowercase letters. All right. These are where more of your articles come in, but revoking more of your documents. So let's go into Article 1. The purpose of this trust shall be so that the trustee can manage and distribute assets to the beneficiaries and ensure the proper and lawful administrations of this estate during the lifetime of the grantor, and in accordance with his will as expressed before the trustees and witnesses. Now let's read Article 2, property of the trust, parentheses, funding and otherwise. The trust holds title to the estate consisting of the personal and real property with all mineral rights and royalties of, which would be your name in all capital letters, registered with district and your county and your state on the date, of course, of your birth, or the date that it was actually registered. If you have a copy of, you go down and find out exactly when it was registered, which it may say on your certificate. The estate includes the heirloom parcel, and we put the actual number that's on the front of the birth certificate, okay, and at the bottom usually, or at the top in red. And the interest is in reversion held in common under QSIP number, which is typically the number in the back of the birth certificate. Some people have that. Some actually have the QSIP number in the front of the birth certificate as well. We have bond lookup services where we can see which one is the QSIP. Arising out of transactions secured by the aforementioned parcel and the chattels annexed thereto. Leasehold interest in existence or as may be acquired from time to time. Okay, so that's that Article 2 of the revocation of the Declaration of Trust. So That's because it's presumed that there is already a declaration of trust out there, because it is. Whether it not be in this format or another, it is there. And it's by definition. So once again here, you guys can review, because I'm just going to kind of sift through. So this is another document that you're going to need here. And as you can see, Article 5, Article 6, trustees' powers, receive assets, receives additional assets, standard of care. All right, these are all of the titles that you actually assume when you are executor and president over your estate. Affirming this with your documents being filed properly, you're getting ready to be in full life. You have to stand on this. You got to study your trust documents and understand who you are now, governing law. Look at that. This trust shall be governed within the court of equity in the county and or under common law jurisdiction of the local territory or republic within the United States of North America. Right. So let's look at liability of fiduciary. Fiduciary is the one who actually handles the dispensation of funds at any time. You are your own fiduciary, or you can appoint someone else as fiduciary at any time on the trust and or estate or for the debt. Now we ended out. This declaration of trust has been executed on April, the date of the day that you're completing this document. But the undersigned trustee will acknowledge that this document is his act, that to the best of his knowledge, information, and belief, the matters and facts set forth herein are true in all material respects, and that this statement is made under penalties of perjury. Here, of course, we have the notary section. And here we go. We have the autographs below, family names first. Once again, you would deal with a few witnesses, or you can do your variations however you feel. Okay, so we've got this one here. Okay. And then we go into our common law copyright. Because what you want to do is make sure you have the copyright claim on your name and its variations. Because what that does is that makes sure that if anyone is to infringe, or it definitely secures a counterclaim or a suit when you've been wrongfully accused of a debt and your name is being used in their system, on their documents, things have been filed. When you make sure that you have a common law copyright notice filed in the tangible medium or venue where they can clearly see that it was, this is what you want to be giving the court, a copy of that copyright notice. Now the judge knows, or he don't want to move no further because he's going to be a party to the suit. Copyright notice, all rights reserved, and read of common law copyright of trade name / trademark, first name and last name in all capital letters. That's what you want to do, as well as any and all derivatives and variations in the spelling of said trade name and trademark - common law copyright. Then your birth date will go there. Your trademark, which will be your first name and last name, uppercase and lowercase, hyphen. Then we're going to do middle name, which would be uppercase and lowercase, and then we're going to go ahead and do colon, and you're just going to put your last name again. What we're doing here is we're showing the different variations put either way on any of their documents. So that's what you're going to be doing in this copyright notice here. Because, when you get letters in the mail, they'll try to make your name look like this and that. You want to try to catch them in any type of variation. So that's why as you go down and you read this notice of copyright, you'll just be filling in these areas. We made sure it was just like this for you, where it says first name, last name, in all capital letters. Take note also, the common law copyright is claimed by a secure party over, including but not restricted or limited to, all means of personal identification of debtor defined as all fingerprints, imprints, palm prints, thumbprints, handprints, toe prints, RNA material, DNA material, blood and blood fractions, biopsies, surgical removed tissue, body parts, organs, hair, teeth, nails, semen, urine, feces, excrements, other body fluids and matter of any kind, and breath samples, voice print, retinal image, and other description thereof, and all other corporeal identification factors and said factors, physical counterparts in any of all body tissues of any kind, in any form, and all records and record numbers, including the results, record or otherwise, of all and any tests performed on any material relating to the debtor, and information. Notice the debtor in all capital letters. That would be your name in all capital letters, which they would, if anyone's filing a claim against you, they're claiming that you're a debtor, but that debtor is your trust and is your property. That's why you put that in all capital letters, and information pertaining thereto, and any visual image, photographic or electronic, notwithstanding any and all claims to the contrary. All right. So we're just getting into this. Y'all can take a look at this. I've already told y'all what was the important things that you guys need to know at the beginning of this. So you can kind of scan through and see the very importance of this copyright notice. Okay. Now, if need be, which I am going to do, I'm going to give you the exact definition of copyright notice. Down at the bottom, same things. You got the notaries, you got the signature section, and there's your examples of how it would look down there. First name, hyphen, middle name, exactly as it looks. Uppercase, lowercase, colon, last name just the same, and secure party signature in parentheses, because that's what that signature is up above, which would be your signature. All right, down low, you know who that is. Notary section. Oh boy. Notice of copyright. So that's notice of copyright, y'all. Notice that that's the third document, and also known as a common law copyright. We'll go into the whole harmless indemnity. All right. Now that's 17 USC code subsection 401. Notice of copyright. USC 17 401. Notice of copyright. All right. And this specifically says the general provision states, whenever a work protected under this title is published in the United States or elsewhere by authority of the copyright owner, a notice of copyright is provided by this section may be placed on publicly distributed copies from which the work can be visually perceived, either directly or with the aid of a machine or device. And Part B, form of notice. If a notice appears on the copies, it shall consist of the following three elements. 1, the symbol copyright, or the word copyright, or the abbreviation COPR, COPR, dot. And 2, the year of first publication of the work, the case of compilations or derivative works incorporating previously published material, the year date of first publication of the compilation or derivative work is sufficient. The year date may be omitted where a pictorial, graphic, or sculptural work or accompanying text matter, if any, is reproduced in or greeting cards, postcards, stationery, jewelry, dolls, toys, or any useful articles, and the name of the owner of the copyright in the work, or an abbreviation by which the name can be recognized, or generally known alternative designation of the owner. C. Position of the notice. The notice shall be affixed to the copies in such manner and location as to give reasonable notice of the claim of copyright. The Register of Copyright shall prescribe by regulation as examples specific methods of affixation and positions of the notice on various types of works that will satisfy this requirement, but these specifications shall not be considered exhaustive. All right then. Evidentiary weight of notice. You ever heard the phrase that doesn't hold any weight? Well, let's look at this. Section D, evidentiary weight of notice. If a notice of copyright in the form and position specified by this section appears on the published copy or copies to which a defendant in a copyright infringement suit had access, then no weight shall be given to such a defendant's interposition of a defense based on innocent infringement and mitigation of actual or statutory damages except as provided in the last section of the 504C. So you guys see that common law copyright notice it held weight and it's going to hold weight. So here we have the hold harmless and indemnity agreement, non-negotiable between the parties. You got the capital letters. We've got the format for you. You already see what size the letters need to be. And of course, you got the address, which will be yours, the creditor, which would be your lowercase. You need to get a private mailbox, i.e. P.O. box, for the creditor. All right. Now, the debtor's social security account number, that's what we want. Your social security number without the dashes. We want that on there because that's your Sister Q trust number. That's your secure levy bond number. Without a shadow of a doubt, people. So this whole harmless and indemnity agreement is mutual agreement upon and permanently entered into on this 31st day of the month of January in the year of your way. So, we're coming from, a natural flesh and blood, spiritual, sentient being. So yes, we're going to say Yahweh 2000, hyphen www, of course, because we're going to go ahead and spell out the year, okay? Between the juristic person, which is all capital letters, Bailey, which will be your Bailey. This is for a precursor for your bonds, y'all. Who is the Bailey? You are the Bailey in lowercase letters, or Bailey uppercase then lowercase letters, or debtor, which would be uppercase lowercase letters / Bailey. Once again, uppercase lowercase letters, because that's how it may be. As we read, it can be like spelled like that, and some will have a dash in it, then have your name that way, including but not limited to any and all variations and derivatives in spelling of said name, except this format. As you can see, you will write your name like that. That's your middle name. First John, middle with the hyphen, boom, and then colon, Doe. Why is it hyphen? Because your middle name is another designation as a actual first name. If they can't get your name, that's why it's called a middle name. That is the name otherwise. That would be a first. Okay. So we go down and scroll down. Okay. And then you'll have a glossary. I know y'all reading that part. So we go to words defined, glossary of terms, and witnessed by hand. This whole harmless and indemnity agreement. The foregoing words and terminology utilized herein are non-obstinate. So now we're going ahead and we are educating the reader or educating the judge or educating the prosecutor. If they've never seen it, they can understand what the terms mean herein. The document, appellation, conduit, creditor, debtor, derivatives, and sledges, which means a creator of the law, an artificial being, as contrasted with a natural person, and sledges, the juristic person, who is that? An abstract legal entity, and sledges such as a corporation created by a construct of law considered possessing certain legal rights / duties of human beings. Sentient living being, as you heard me state earlier, y'all. Hold harmless indemnity agreement document in hand shows that it is the creditor, a living, breathing flesh and blood woman and man, distinguished from abstract legal construction, such as an artificial entity or juristic person, corporation. The birth certificate, the all caps that's used by the so-called creditors who try to call you the debtor, the mail jurors. Anyways, so you sign, we date, attachment A, which is your property list. All of your property lists, putting them on notice of all. This one right here is the getter, y'all. This one right here is the one that they got and can't say they have everything. Read this would be all your estate and all properties acquired in the future or past acquired, taken or seized unlawfully, etc. You're coming. You're coming. So go ahead. All biometric data, all rights to obtain and refuse authorized administration of any foods, beverage, nourishment, water, any substance to be infused or injected into affected by the body or means whatsoever. Go ahead, y'all. Just go ahead, keep reading. I'm just let y'all read that all rights as outlined in the Constitution for the United States of America and in the Honorable Bill of Rights. All rights to exercise freedom of religion, worship under the sacrament, spiritual practice, and expression without any abridgment of free speech, or the right to publish, or the right to peaceably assemble, and the right to petition the government for redress of grievances, or the right to petition any military force of the United States for physical protection from threats to safety and integrity of person or property by either public or private sources. Okay, that was y'all see where we going, and we got let's keep going. We got now they cannot say, they would have to do a lot of studying of what you have if they want to try to bring a claim against you. All right, that's the whole harmless indemnity. All right, let's get into it. Now here I would go to a bill of exchange, but we're not going to go there yet. All right, so what I want y'all to do now is understand, this is a UCC1 claim. This is the superior lien that you would place on all of your estate. You would have the superior claim, superior lien filed with the state or regionally. Before they will place a lien, they'll see up. He got to it before we did. We cannot proceed with putting the lien, which means they have to really negotiate with you and get the damn picture. This is another individual that I worked with where we did at UCC. We definitely went ham on this. So you in the collateral box would be all of the instruments, all of your real property. And just as we had listed in our property section on the whole harmless indemnity at the end, you would try to fit most of that in the collateral box. You would make the organization's name and the debtor the one who's claiming to be the creditor. Now we're going to make them the debtor to us, and we're the secure party and organization in this matter of this lien. Okay, it's going to be the debtor is a transmitted utility, and the secure party is the bailee or bailer, and everything is held in trust. You see down at the bottom, we checking those boxes in the collateral section. If y'all could see that and read that, the real property's address, the real property legal description of what we're liening. We're going to lien the parcel number as well, social security number. We're going to say it again, social security number without the dashes. All right, we're going to say this is an actual and constructive notice that all assets and proceeds of the debtors known, owned, or hereafter acquired is hereby accepted as collateral for securing contractual obligations in favor for secure party. This is a public notice of a commercial transaction and that secure party has perfected a security interest and hereby secures all rights in its possession of certificate title and has superior proof of claim and real and personal property described thereof. All collateral property instruments and proceeds listed thereto is herein claimed and liened. Deed of trust / instrument number 201-605-78826. Okay. Deed of real living reconveyance / instrument number 201-705-0508. Under Article 4, Section 1 of the U.S. Constitution, all states must give due recognition of all of other states / acts, filings, and documents, etc. This will be your addendum page. And usually if you're electronically filing, you can add your trust documents if they're properly uploaded, scanned in, and saved in the proper format that it can receive. All right, y'all? So bear with me because we're getting ready to get deep into it. Y'all see all these forms. All right, so Affidavit relating to title. Affidavit relating to title. Who holds the supreme title? You do. You have the superior lien. You are the president. You are the owner. You're the maker and the creator, so to speak. So to speak, by natural standpoints, because you're actually the signatory to it at this point, who have superior claim. Your mother and your father technically was the originator. They signed the original document, not the birth certificate, most of the time. But we need to check and make sure how it's done today by going down to your vital statistics and seeing if they did some extra. But anyways, okay, so